Welcome to the morning feed. We're talking today about a story out of Michigan involving a teen who was arrested for falling asleep in court. Many people have probably already seen the headline, but the whole situation has been elevated now to a lawsuit against the judge and his security. So, we're going to go over the court filing. We're going to go over the press conference announcing the lawsuit. They're seeking $75,000 in damages, and we're going to get into the whole story. I don't think a lot of people understand the full weight of what happened here. When you just read the headline, you may develop a very different opinion than if you know the whole totality of everything. So I think this is a situation that is important to shed some light on. So that's what we're going to do today. Let's go over to the newest court filing right after we go over just a little basis here. So, just so that everybody is aware, the judge has been removed from the bench temporarily, pending more training, I believe is what they said. Let's read this article real quick from the Detroit Free Press. So, a Detroit judge who had a teen girl handcuffed and threatened her with jail time for sleeping in his courtroom and giving him attitude has been removed temporarily from his docket in order to undergo training, according to a statement from the chief judge in the district. Now we're going to scroll down just a little bit here. We hope these these steps will help to assure the public of the 36th district um, about our integrity and fairness. So they're taking some actions from within the court to have an internal review of the situation, also temporarily removing him from the docket so that he can't be overseeing anything else. And it says, we sincerely hope this incident does not undermine our long-standing relationship with local schools. Our thoughts and actions are now with the student and her family, and we are committed to taking these corrective measures to demonstrate that this incident is an isolated occurrence. Well, we're not so sure. I mean, this specific thing that happened is so the child who was arrested was attending King's Court earlier this week with a nonprofit on a field trip. And in between the hearings, King addressed her and her peers. And at one point, he appeared to see her falling asleep. And he started shouting at her. Eventually, he has had her detained. She is eventually released, but until she is forced to wear, but not until she was forced to wear a green jail jumpsuit. She was cuffed, and so she would have been required to change her clothes there in front of the jail staff and put on the green jail jumpsuit, be handcuffed in front of the entire class, pleaded for forgiveness. It is quite a scene, actually. The child's mother told the Free Press on Thursday morning that her daughter was likely tired because of the family currently does not have a permanent place to stay. They did not go to bed until late the night before. She also mentioned how her daughter's feeling afterwards. She doesn't want to come outside. She doesn't want to talk to her friends. Like she just, according to her mother, she feels nervous. She feels intimidated. She feels embarrassed. Um, I do know that in the middle of this incident, there is something inaudible on the video, because this was streamed out, this whole incident. So there's something on the video that's inaudible that the teen says to the judge. And there have been people wanting to know, well, what did she say to the judge, to kind of like allegedly elevate the situation as it seems. And I'm unsure in that situation. I mean, unless she made a very violent threat or something, I just I don't know what was actually said, but there have been people that brought that up. They did in the press conference even today. So take that for whatever you want to, but I just don't see how the actions were acceptable at all, especially in the fashion that he handled this whole situation and kind of making like this whole very theatrical trial like approach, in a way that you wouldn't even do it with a normal defendant on trial. Very, very odd. And, people, if you're watching trials, like, have you seen how many times people in the courtroom fall asleep? Like, all the time. All the time. And I understand that those children were there with the nonprofit. They were brought there to understand the court process and they want them to take it seriously. But I do feel that he absolutely overstepped. Some people disagree with that, but I don't know if they understand the whole story. And some people, they just have a very different approach and opinion to how to discipline a child. So let's go over here. This is the complaint. Made this nice and big, so hopefully it is legible on the screen if you are watching and wanting to follow along in that way. We will also post this um, on our Patreon and share it out on social media so everybody can look at the filing themselves if they would like to. So now comes plaintiff ELG, and when we say ELG, that is the teen who is who the lawsuit has been filed in their honor. A minor by parent and next friend, Latoria Till, who states the following for her complaint against the defendants. Miss ELG fell asleep in class. She was the involuntary attendee of a guest lecture that her employer slash vocational trainer arranged to occur. The venue of the lecture was room 234 and the 36th District Court. Of the 36th District Court. I apologize. I really don't want to edit this episode, so there may be some slip ups and we're just going to leave them. So during the lecture, defendant King felt personally disrespected when the teenager expressed her opinion of the lecture by nodding off during the presentation. Streaming the lecture live from the court's YouTube platform, defendant Judge King decided to enact his own version of the reality show Scared Straight. And this is not just an allegation by them saying, like, this is basically what this person did. No, he said that himself in I'm trying to remember who he was speaking to when the judge said it, but he referenced Scared Straight himself when speaking about this incident. So he tried to enact his own reality TV show, Scared Straight, by ridiculing Miss ELG in front of her peers and the defendant's online followers. He made Miss ELG an unwitting actor in his improv version of the Star Chamber. He berated the minor live on the platform, ordered her jail, caused her to be handcuffed, demanded that she take off her clothes and change into jail garb, imprisoned her for hours, and then and this is where the rest is bad, but this is where, for me, this is like an aggravating factor. Held a fake trial with her classmates and possibly his internet followers and her jurors and his audience. Defendant King's extrajudicial actions violated the minor's constitutional rights, subjecting him and the other defendants to a liability as stated in the balance of this complaint. Any defense of immunity will fail, and they're talking about judicial immunity. Because as you'll hear in the press conference, they go over judicial immunity and why it does not apply in this situation. So they're trying to say he did this as an individual, not acting as the judge. So they go over jurisdiction, and we'll just kind of skip over that a little bit. It's just a bunch of legal jargon that has to be in the lawsuit. Parties and venue. We already know who the parties are, and the other parties in this is Universal Protection Services. So They were doing business as Allied Universal Security Services. They're at the courthouse, so they are included in this. Factual allegations. The events giving rise to this lawsuit occurred on August 13th. 15-year-old Miss ELG was participating in a vocational program run by a local nonprofit organization. The nonprofit employed teenagers to plant foliage around the city of Detroit and organized programs to teach youth how to succeed in the workforce. The nonprofit had organized a field trip to the 36th District Court for August 13th, where students who wanted to be attorneys could learn about a career as a lawyer. The venue selected was the 36th District Court. The lecturer was defendant Judge King, and his name is Judge Kenneth King. Miss ELG did not learn about the scheduled trip until she arrived at her work site, prepared to plant trees that day. She was not interested in the practice of law and instead aspired to be a cardiothoracic surgeon. Permission for Miss ELG's participation in the trip was not sought from her mother. Otherwise, she would have stayed home or attempted in advance to arrange to work with a crew that was not scheduled to travel to the court. Miss ELG arrived for work and was bused to the court building. When she arrived, she was seated in the gallery of the courtroom assigned to defendant Judge King. Court was briefly called, and the young people were required to observe a homicide proceeding that was presided over by defendant Judge King. I think if your minor child is this is not in the lawsuit. This is my conjecture here. We got to add in our sound buttons so you know when I'm jumping in with opinion. But I don't think a minor child should be subjected to sitting through a homicide proceeding without their parents knowing about it. So just put that out there. I wouldn't be happy if this was done with my minor child. The court went into recess after the proceeding, and the defendant Judge King's role changed from judge to teacher. Defendant Judge King left the bench and asked the young people whether any of them wanted to be a judge. One young man raised his hand, and defendant Judge King disrobed and donned. Disrobe sounds it they probably should have used some different verbiage there. They meant he just took his judge robe off. He didn't take the situation that far. One young man raised his hand, and the defendant disrobed and donned the child with his judicial apparel and seated him on the bench before proceeding with a monologue regarding the practice of law. Although the court was no longer in session, defendant Judge King broadcast his lecture publicly using the court's YouTube platform, permitting his followers and fan base to both observe and comment. An otherwise shy, polite, and courteous Miss ELG, who was not interested in the practice of law and who had a rough night's sleep, unintentionally expressed her disinterest in the proceedings by nodding off after being exposed to a court hearing that forced her to relive a traumatic event, causing her to shut down. Though neither she or her mother consented to the attendance at a hearing involving violence or the use of her image and identity on a public platform during an educational seminar, defendant Judge King publicly berated and humiliated Miss ELG for nodding off, falsely casting her as a juvenile delinquent because, as he later stated, he was disrespected. Miss ELG quietly apologized, and defendant Judge King temporarily moved on. However, despite her efforts to be attentive, the child could not stop her mind from seeking its safe space and nodding off again. Well, it says nodding back off. Defendant Judge King, I wish I could write for these people. Defendant Judge King confronted Miss ELG again for sleeping in class, instructing her that perhaps she needed to go to the restroom and get a drink of water. Defendant Judge King told Miss ELG to go relieve herself because of what he had in store for her. Oh boy. I don't even know what I'd think if a judge told me that. It is apparent that he developed a plan for the amusement of his followers and fan base to cast Miss ELG unwittingly in what he later described as his own episode of Scared Straight. Miss ELG was greeted by the defendant, John Doe, court officer. They're still trying to track down some names in this case, by the way, so some of these people are not yet named. A court officer as she returned to the gallery to sit beside her classmates before Judge King convened court. Um, the court officer first derided Miss ELG and accused her of disrespecting the judge. Then the defendant, the court officer, directed Miss ELG to the side of the bench and restricted her movement by ordering her to stand still as a real defendant was escorted out of a detention cell. So they're also putting a minor child in contact with adult actual defendants. The court officer next directed Miss ELG into a detention cell and locked her inside while defendant Judge King brought court into session and called his first case. Approximately 10 minutes later, the court officer opened the detention cell, handcuffed Miss ELG, and directed her to another cell where she was told to strip her clothing and put on a jail jumpsuit. Miss ELG removed her hoodie but told defendant Jane Doe, court officer, that she would not take off the rest of her clothing. Good for her. Evidencing that defendant Jane Roe, it says, the court officer, and then the male court officer knew that Miss ELG was an unwilling participant in a farce. She was permitted to put the jumpsuit over her clothing before being handcuffed and transported back to the original holding cell, where she was held captive for hours before being recuffed and brought into the courtroom after the close of the day's proceedings, where a fake trial was convened. Further evidence of the phoniness of defendant Judge King's reality show is the absence of a case number for Miss ELG. Additionally, despite the entire episode being broadcast on YouTube, upon further information and belief, there is no court record of the sham proceedings. The sham proceedings continued. Judge King caused a random private attorney to pose as counsel for Miss ELG. On live internet television, defendant Judge King coerced a minor to disclose her name and other personal information, such as her age and the name of her high school, to his followers of the show. Defendant Judge King then threatened to send Miss ELG to juvie with vulgar stories of beatings and feces on the county's juvenile detention center, falsely casting her as a dishonest, disrespectful delinquent, and simultaneously publicly disparaging the conditions of a county-operated facility where judges with appropriate jurisdiction and proper findings of fact have been determined with due process of law are required to send juvenile offenders. Then, and I just will say, most of them, like, they are bad. The conditions are bad in juvie. And any jail in the United States. Shout out to Georgia, who has probably some of the most horrific jails. Then making a mockery of the justice guaranteed by the due process clauses of the United States Constitution, while panning the camera to focus upon his juvenile audience for the benefit of his internet fans. Judge King asked Miss ELG's peers to serve as a fake jury of public opinion and decided whether to let her go home to her mother and her grandmother, or to serve time in the juvenile jail that had been but moments before denigrated as unfit. Of course, defendant Judge King was not going to send Miss ELG to jail as there was no actual case or controversy, and because he admitted to the press that the foregoing was simply his version of Scared Straight. Rather than using the press as an opportunity to extend an apology for what may have been labeled as extreme and outrageous conduct on the judge's part, Judge King doubled down by telling reporters that Miss ELG had a bad attitude, was disrespectful, and required his mentorship while simultaneously offering a watered-down acknowledgement that he lacked jurisdiction to hold Miss ELG in contempt, knowing that the conduct that disturbed him occurred during a lecture where he served not as judge but as teacher in a venue that he had transformed from courtroom to classroom, telling the public that he probably did not have the authority to jail her. Common sense and the facts demonstrate that a grown man became rattled by a young girl that he falsely concluded to be and cast as a delinquent, who was actually a fragile teenager forced to attentively face a past trauma during an actual prior court proceeding that had ended, before shutting down during class. As a result of his anger, the defendant immaturely decided to teach the girl a lesson in front of her peers and his internet audience. So that is the gist of what happened. Um, she was not being held for an actual crime or anything else, for falling asleep in court. And he found it quite offensive that she fell asleep in his courtroom, and he decided that it was disrespectful and decided to take some very extreme measures to deal with that and how he felt about it personally. And that's one of the things you're not supposed to do as a judge, is insert what were your personal feelings about something, but what what were you teaching in the first place? You're teaching these kids that due process just doesn't exist, for starters. You're not teaching them how a court actually is supposed to work in our country. And a lot of what I just scrolled past goes over that. She wasn't being held with a crime. She didn't actually commit a crime. There was no reason by law for this type of action anyway, had she been even an adult sitting in that courtroom. Adults fall asleep all the time in court. Anyhow, I understand the sentiment, why she was there, the program she was there with. They wanted them to take it seriously and pay attention, but this is not the way. So I scrolled past a lot of the stuff that talks about the due process of it all, because I think many people would understand that and why she was not actually able to be charged with any type of crime. So let's go over the lack of immunity, because I think this is something that will be less understood by the general public. Plaintiff hereby realleges and incorporates individually every numbered allegation contained in the preceding paragraphs of this complaint as if fully set forth herein. It is expected that defendant Judge King will claim that he is judicially immune from liability in this lawsuit. The doctrine of judicial immunity is often called absolute. So there's a certain amount of immunity a judge is afforded by being a judge in their capacity. There's a lot of things that a judge cannot be. Um, you can't go after a judge for doing certain things from the bench, or certain rulings, and certain fault or issue you may take with the judge. You can't just go after the judge for that. They have a certain amount of immunity. Rather than being truly absolute, the doctrine itself is limiting. Judges are only immune from liability for acts done within the scope of their judicial authority and over which they had jurisdiction. It is clearly established that judges are subject to liability when they act outside of their judicial capacity. For example, when they perform the administrative duties of hiring and firing. In that regard, it has been held that a judge is liable for the discriminatory termination of a court officer. Um, let's scroll past this a little bit. Judge performs many non-judicial acts, so they do a lot more than just their ruling from the bench. Judges may serve as adjunct legal professors teaching law students, or they may serve as keynote speakers at public events. And Judge Kenneth King does, and he has also been removed from teaching in the meantime of all of this. I don't know if he's been permanently removed from teaching. It may also be temporary. Upon information and belief, Judge King has in fact served as an adjunct law professor Certainly, the defendant would not claim that he possessed the authority to hold a law student in contempt of court for sleeping in class because, in addition to serving as a professor, he carried the title of judge. Nor would a judge believe that a heckler at a speaking event could be jailed by him for interrupting him. Precedent dictates that the location of the venue does not alter the function of the speaker. In other words, teaching the class in the courtroom does not transform the function of the person from teaching to adjudicating. Rather, it has been held when it is beyond reasonable dispute that a judge has acted out of personal motivation and has used his judicial office as an offensive weapon to vindicate personal objectives, and it further appears that no party has invoked the judicial machinery for any purpose at all. Then the judge's actions do not amount to judicial acts, even if the acts occurred in the courthouse and a record of the bogus attempt proceeding was made by a stenographer. In this matter, Miss ELG was on a field trip to the court. The 15-year-old was not in the courtroom for legal process. Judge King was acting as a lecturer, and the court was not in session when Miss ELG is alleged to have fallen asleep. Moreover, it appears that the judge simply disliked her after judging her body language and assuming that he knew what her attitude portrayed. The perceived attitude offended the judge, and his personal objective was to punish her by scaring Miss ELG straight. So it goes on to talk about how they conducted a fake trial with a real incarceration before an internet audience. They also go over how they lack all jurisdiction to punish the conduct using the contempt process described above. In this fake trial, he acted as a producer, broadcaster, complaining witness, arresting officer, finder of fact, judge, and disciplinarian. And then it accuses the court officers, the correction officers are likewise not entitled to quasi-judicial immunity or qualified immunity, as they were private security guards who were not performing adjudicative functions in this matter, and because judicial immunity is inapplicable. This is going to be very interesting to see how the court handles this and what rulings they approach this with. The court officers are not entitled to governmental immunity under the statute because they are not officers or employees of a governmental agency, and they acted with actual malice by performing the ministerial acts of arresting, handcuffing, and incarcerating Miss ELG. I have a feeling that the court officers may end up being able to get off of here, but we'll see how that goes, because they would have been acting what they felt was under the direction of a judge, and so their part in this may go away, I would think. But I am not a lawyer, and that is just opinion. So the malicious prosecution in violation of the Fourth Amendment, it goes over basically how she was publicly impugned her character, and it damaged her reputation in a non-judicial type role without jurisdiction in a fake trial. It goes over a lot of the stuff that we've already just read about. They are saying that her injuries from being handcuffed, arrested, imprisoned, disrobed, and cast in a false light include, but are not limited to, severe emotional pain and suffering, mental anguish, severe emotional distress, fright and shock, denial of social pleasures, and humiliation and mortification. So they're seeking compensation for past, present, and future pain and suffering, mental anguish, emotional distress, fright and shock, compensation for medical expenses, including psychological and psychiatric treatment, exemplary damages, cost, interest, attorney's fees, expert witness fees, And they're asking for all of that in the way of $75,000. So most of the rest of the verbiage here in the lawsuit is repeating in the various ways that they need to in legal speak to be able to get their point across of what they're asking for and what grounds they have, and um, what facts and evidence they may have to add to this. So it is a 56 pager. So I won't go over the entire thing and keep repeating everything over and over and over again. But go to the um, we will go to the press conference just so that everybody can kind of see what exactly happened there. Hang on just a moment. There was a press conference with the attorney and the teen's mom, and I think that it's helpful to check that out and just see kind of what they have to say about it. And that's going to be it for now. We'll continue to report on this as it moves through the court system to see how they're going to rule on these matters, what they end up doing with this. But this is a very important matter. And I don't think people understand the full story of what happened here with them actually making a mock trial, having it streamed. I mean, it's very egregious. So even for people who may not completely agree with everything and think that maybe the judge was within his rights, which I definitely disagree with. Um, the totality of the situation is quite disturbing, actually. So let's go here. Oh, we did not mean to do that. YouTube and their advertising. So we'll go over this real quick. Now I've got to fix one thing real quick. Okay, sorry, I forgot to turn the ads off. Anyhow, that was the press conference that they had to announce the lawsuit. And I didn't give much commentary there. I have a lot of opinions about that press conference and some of the questions that were asked and um, some of the inferences that were made were just highly unnecessary. The situation is what it is, no matter what their situation is, if that makes sense. So, anyhow, we'll continue to cover this because this is a very important issue, and we judge the conduct of all professionals in the courtroom is something that absolutely has to be upheld in due process. And the image that we paint um, for teens in the courtroom of how the process works, because that's not how the process works.